Order. The Pledge of Allegiance will be led by Representative Clifford.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Schiebel, please call the roll.
Representatives Armagost, Bacon, Barone, Byrd, Basenecker, Bottoms, Bradfield, Bradley, Brooks, Brown, Caldwell, Camacho, Carter, Clifford. Representative DeGraff is excused. Duran, English, Espinoza, Ferre, Froelich. She's there. Oh, yeah. Garcia, Garcia Sander, Gilchrist, Gonzalez,
I am here.
Hamrick, Hartsook, Jackson, Johnson, Joseph, Kelty. It's right there. Leader, Lindsay, Linstead, Luck, Representative Luck,
Excused.
Lukens, Mabry, Marshall, Martinez, Morrow, McCormick, Pascal, Phillips, Puglisi, Richardson, Ricks,
Here.
Rootnell, Ryden, Sirota, Representative Sirota, Sirota is excused. Smith, Soper, Stewart K, Stewart R, Representative Stewart R is excused. Story, Sukla,
Thank you.
Taggart, Titone, Valdez A, Velasco, Weinberg, Wilford, Representative Wilford,
Excused.
Winter, Woodrow, Woog, Woog,
Excused.
Zokai, and Madam Speaker.
Here. With 60 present, 5 excused, we do have a quorum. Representative Clifford.
Madam Speaker, I move that the Journal of Wednesday, March 19th, 2025 be approved as corrected by the Chief Clerk.
Members, you have heard the motion that the journal be approved as corrected by the Chief Clerk. All those in favor say aye. All those in favor say aye. All those opposed, no. The ayes have it. The motion is adopted. Members, I'll invite you to move to your seats. We do have business to attend to. Madam Majority Leader.
Thank you, Madam Speaker. I move to proceed out of order for consideration of Senate Joint Resolution 13.
Seeing no objection, we will proceed out of order for consideration of Senate Joint Resolution 13. Mr. Schiebel, please read the title to Senate Joint Resolution 13.
Senate Joint Resolution 13 by Senator Judah, also Representative Zokai, concerning recognizing Thursday, March 20th, 2025 as Nowruz Day.
Representative Zokai.
Thank you, Madam Speaker. I move Senate Joint Resolution 13 and Amendment L001 and ask that it be properly displayed.
Thank you, Representative. The resolution has been moved. Separately, we have moved an amendment. Please describe the amendment.
Thank you, Madam Speaker. This is a technical amendment to put in the words that the House is concurring herein. Otherwise, don't know what we're doing. So ask for an aye vote.
Seeing no further discussion, the motion before us is the adoption of L001 to Senate Joint Resolution 13. Mr. Schiebel, please open the machine and members proceed to vote. Representative Ricks, how do you vote?
Yes.
Representative Ricks votes yes. Representative Gonzalez, how do you vote?
Yes.
Representative Gonzalez votes yes. Carter, Bottoms, Bradley, Gonzalez. Oh, Gonzalez we have. Representative Bradley is excused. $6 fine. Please close the machine. With 61 ayes, 0 no, and 4 excused, L001 is adopted. Representative Zokai.
Thank you, Madam Speaker. I ask that Senate Joint Resolution 13 be read at length.
Mr. Schiebel, please read our resolution.
Whereas Nowruz, meaning New Day, is an ancient festival celebrated by millions of people of Iranian, Kurdish, Afghan, and Central Asian heritage around the world, marking the arrival of spring and the Persian New Year. And whereas Nowruz has been observed for over 3,000 years as a time of renewal, reflection, and unity, bringing together families and communities in celebration of hope, harmony, and cultural heritage. And whereas the tradition of Nowruz, including the Haft-Seen Table, the Chahar Shanbeh Suri Fire Festival, and Sizdah Bedar, promote values of renewal, gratitude, and environmental stewardship. And whereas Colorado is home to a vibrant Iranian-American community that enriches the cultural fabric of our state through contributions in academia, business, the arts, and public service. And whereas the Women Life Freedom movement, rooted in Iran, represents the aspiration of a society that honors human rights, particularly women's and children's rights, gender equity, and economic justice. And whereas recognizing Nowruz fosters inclusivity and affirms Colorado's commitment to celebrating the diverse cultural traditions of its residents. Now, therefore, be it resolved by the Senate of the 75th General Assembly of the State of Colorado, the House of Representatives concurring herein, that the Colorado General Assembly honors the celebration of Nowruz, extends best wishes to all those observing this joyous occasion, and recognizes the contributions of the Iranian-American community to the state of Colorado.
Representative Zokai.
Thank you, Madam Speaker. I would like to start with a poem by Feridun Moshiri. باز کن پنجره ها را که نسیم روز میلاد عقاقی ها را جشن میگیرد و بهار روی هر شاخه کنار هر برگ شمع روشن کرده است. همه چلچله ها برگشتند و تراوت را فریاد زدند. باز کن پنجره را و بهاران را باور کن. Open the windows. The breeze celebrates the earth's birthday, and spring has lit a candle on every branch next to every leaf, and the sparrows have returned and cried out for vitality. Open the windows and believe the spring. Thank you, members. You may be seated. Members, it is an honor to stand before you this morning as the first Iranian elected to the legislature. And as a founding member of the Manasa Caucus. Today, we recognize and celebrate Nowruz, the Persian New Year, a tradition that has endured over 3,000 years. Nowruz means new day in Farsi and marks the arrival of spring, a time of renewal, hope, and triumph of light over darkness. Nowruz occurs at the spring equinox, so it changes every year. It was at 3 a.m. last night, and Judiciary nearly made it to ring in the new year with all of us. Across the world, over 300 million people observe this day, coming together with family and community to welcome the possibilities of a fresh start. From lighting bonfires to setting the half scene, every tradition reflects our shared human desire for health, happiness, and peace. And on your desk this morning, you have some desserts to enjoy as well. The tradition of Nowruz means a lot to me and my family. I have been celebrating Nowruz since I was born, and now I get to pass it on and celebrate it with my children. It's a time for me to reconnect with my Persian roots. We spend this time cleaning our house, exchanging gifts, and visiting the members of our community. And this time of year, I also am thinking of my grandmother. She came here during the Iranian Revolution with her 20-year-old daughter, my mother, and they did not have anything. They worked multiple jobs. They learned a new language. They faced great discrimination and struggles, and it is because of all that they endured and sacrificed that I am able to stand before you today. My grandmother passed shortly after Nowruz about 10 years ago. She pushed hard to make it through for the holiday, and I always think of her at this time of year. Nowruz is not just about welcoming spring, but it is also a time to reflect on those who came before us and the values that they instilled in us, values of perseverance and gratitude. At a time when our communities may feel attacked, I appreciate the celebration of cultures that enhance our state. Iranian communities strengthen the cultural fabric of our society and remind us that the beauty of Nowruz lies in the universal message of unity and that diversity is strength. This resolution also reflects our state's commitment to standing in solidarity with movements that champion human rights, equality, and freedom. And I must recognize the Woman Life Freedom movement in Iran that is being championed by young men and women who are putting their lives at risk, and many have lost their lives, all to push for a society that values gender equity, economic justice, and human rights for all. Nowruz reminds us that no matter how dark things may feel, the light always comes. It teaches us that every challenge can be met with hope. And colleagues, as we are mid-session, you may feel the need for a fresh start. So I invite you all to join me in celebrating a new year and moving forward with this message of renewal and optimism. And Eid Shoma Mubarak. Happy New Year.
Seeing no further discussion, the motion before us is the adoption of Senate Joint Resolution 13. Mr. Schiebel, please open the machine and members proceed to vote. Representative Ricks, how do you vote?
Yes.
Representative Ricks votes yes. Representative Gonzalez, how do you vote?
Yes.
Representative Gonzalez votes yes. Carter, please close the machine. With 61 ayes, 0 no, and 4 excused, Senate Joint Resolution 13 is adopted. Co-sponsors. Please close the machine. Members, our next order of business is third reading. Mr. Schiebel, please read the title to House Bill 1209.
House Bill 1209 by Representatives Lindsted and Wilford, also Senator Gonzalez, concerning measures to address the efficiency in the regulation of marijuana licensees and in connection therewith reducing an appropriation.
Madam Majority Leader.
Madam Speaker, I move House Bill 1209 on third reading and final passage.
The motion before us is the adoption of House Bill 1209 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Gonzalez, how do you vote?
Yes, and I request to be a co-sponsor as well, Madam Speaker.
Thank you, Representative. We'll get to co-sponsors momentarily. Representative Gonzalez votes yes. Please close the machine. With 45 aye, 18 no, and 2 excused, House Bill 1209 is adopted. Co-sponsors. Representative Gonzalez, co-sponsors.
Yes, Madam Speaker, absolutely.
Thank you, Representative. Please close the machine. Mr. Shebel, please read the title to House Bill 1182.
House Bill 1182 by Representatives Titone and Brown, also Senators Cutter and Simpson, concerning tools to assess risk for the purpose of underwriting property insurance policies.
Madam Majority Leader.
Madam Speaker, I move House Bill 1182 on third reading and final passage.
The motion before us is the adoption of House Bill 1182 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Gonzalez, how do you vote?
No.
Representative Gonzalez votes no. Please close the machine. With 45 aye, 18 no, and 2 excused, House Bill 1182 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1224.
House Bill 1224 by Representatives Titone and Soper, also Senator Snyder, concerning modification of the revised Uniform Unclaimed Property Act.
Madam Majority Leader.
Madam Speaker, I move House Bill 1224 on third reading and final passage.
The motion before us is the adoption of House Bill 1224 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Gonzalez, how do you vote?
No.
Representative Gonzalez votes no. Please close the machine. With 50 aye, 13 no, and 2 excused, House Bill 1224 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1298.
House Bill 1298 by Representatives Carter and Richardson, also Senators Exum and Michelson-Janay, concerning judicial performance commissions.
Madam Majority Leader.
Madam Speaker, I move House Bill 1298 on third reading and final passage.
The motion before us is the adoption of House Bill 1298 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Gonzalez, how do you vote?
Yes.
Representative Gonzalez votes yes. Please close the machine. With 63 ayes, 0 no, and 2 excused, House Bill 1298 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to Senate Bill 78.
Senate Bill 78 by Senator Pelton R., also Representatives Lukens and Weinberg, concerning the authorization of certain nonprofit hospitals to enter into collaborative agreements with other health facilities.
Madam Majority Leader.
Madam Speaker, I move Senate Bill 78 on third reading and final passage.
The motion before us is the adoption of Senate Bill 78 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Gonzalez, how do you vote?
Yes.
Representative Gonzalez votes yes. Zokai. Please close the machine. With 63 ayes, 0 no, 2 excused, Senate Bill 78 is adopted. Co-sponsors. Please close the machine. Members, I have an announcement. Representatives Byrd, Sirota, and Taggart will be excused at such time as needed so that the Joint Budget Committee can meet. Madam Majority Leader.
Thank you, Madam Speaker. I move the following bills be made special orders on March 20th, 2025 at 9:37 a.m. House Bill 1187, House Bill 1236, House Bill 1290, Senate Bill 51, Senate Bill 23, Senate Bill 14, Senate Bill 67, and House Bill 1222.
Seeing no objection, the bills listed by the Majority Leader will be made special orders today, March 20th at 9:37 a.m. Representative Camacho. Members, you have heard the motion. Seeing no objection, Representative Camacho will take the chair.
The committee will come to order with your unanimous consent. The bills will be read by title unless there's a request for reading a bill at length. Committee reports are printed in your bill folders. Floor amendments will be shown on the screen on iLegislate and in today's folder on your box account. Bills will be laid over upon motion of the majority leader. The coat rule is relaxed. Mr. Shebel, please read the title of the House Bill 251187.
House Bill 1187 by Representative English concerning the release of certain documentation submitted to the court in a proceeding related to a civil protection order.
Representative English.
Thank you, Mr. Chair. I move House Bill 251187
That's proper
to
motion.
the committee and the committee report.
To the committee report. Representative English.
Oh, okay. Sorry. Okay.
Representative English.
I just want to say I amended the bill per se CASA and victims' rights. And
Assistant Majority Leader Bacon.
Thank you, members. I just wanted to speak to the committee report. The bill changed, but what we did in the bill was per some requests from some of the victims' rights groups in regards to how we deal with disclosing private information. And so the committee report has essentially become the bulk of the bill. And what it just says is that both parties have an opportunity, if information is required of them or information about them should go out, that both parties have an opportunity to ask the court to keep that information suppressed. And so, again, the crux of this bill now is the amendment, and with that, we urge an aye vote on the committee report.
Is there any further discussion on the committee report? Seeing none, the question before us is the passage of the committee report. All those in favor say aye. Aye. All those opposed say no. The ayes have it. The committee report passes. To the bill, Representative English.
thank you, Mr. Chair. House Bill 251187 addresses a critical need for the protection of individuals' confidential information within legal proceedings. By establishing robust guidelines for the handling and dissemination of sensitive data, this legislation aims to safeguard personal privacy while ensuring that all parties involved in a legal case have access to necessary information. So it's not keeping information from a victim. They do have access. It's just limited through the courts. The primary focus of House Bill 251187 is to create a framework that delineates what constitutes confidential information and the circumstances under which it can be disclosed. This is essential in maintaining the integrity of the judicial process, as it helps prevent the misuse of sensitive information that could lead to personal harm or unjust bias. The bill emphasizes the role of the court in overseeing the management of confidential information by allowing the court to exercise discretion in determining which information is essential for the parties involved. The legislation promotes transparency and fairness in legal proceedings. This careful balance between confidentiality and the need for information fosters trust in the judicial system, encouraging individuals to participate fully without the fear of their private matters being exposed. This is a significant step toward enhancing the protection of confidential information in legal contexts. It not only aims to uphold individual privacy rights, but also ensures that the legal processes remains equitable and just for all participants. By implementing these necessary safeguards, the bill contributes to a more secure and trustworthy judicial system. And as we can see, there's been a lot of issues with
Representative
us.
English. Colleagues, while we are discussing House Bill 1187, I request that you please keep your volume lower or move your conversations to the side while we're here during discussion. Representative English.
Thank you, Mr. Chair. Let me just read that last paragraph while I have everybody's attention. It was kind of loud, so I appreciate you, Mr. Chair. This is a significant step toward enhancing the protection of confidential information in legal contexts. It not only aims to uphold individual privacy rights, but also ensures that the legal process remains equitable and just for all participants. By implementing these necessary safeguards, the bill contributes to a more secure and trustworthy judicial system. And as we in here ourselves have had issues about people coming to our houses and things like that and knowing our confidential information, I think this is also an important bill to elevate, and I ask for an aye vote. Thank you.
Committee members, just a friendly reminder, please keep those conversations a little bit lower while we're discussing House Bill 1187. Representative Soper.
Thank you, Mr. Chair, and it's an honor to serve with you.
It's an honor to serve with you.
Members, I was a no vote in committee and will remain a no vote on the bill. This bill actually does the opposite of what you would logically think should be happening. Instead of the person who sought, for example, the protection order to have their confidential information kept confidential, it instead flips that to the alleged perpetrator. The person who's subject to the protection order would be the one to control whether or not certain information would be released or not released. The other thing that I do want to point out is right now, today, we could actually seek a background check on an individual and find out the exact same information that this bill is seeking to have rigid timelines to protect. Because of that, this is not the level of privacy that the bill envisions, and therefore I will remain a no vote. Thank you.
Representative Caldwell.
Thank you, Mr. Chair. I move L002 to House Bill 1187 and ask that it be properly displayed.
That is a proper motion. And Amendment L002 has been properly displayed. Representative Caldwell.
Thank you, Mr. Chair. This is just a simple safety to petition clause. There are two parties involved, two sides of the equation in this, and so it seems proper to have a petition clause because when there's two different sides of this issue involved, you need to give one side at least the ability to petition this before it goes into effect. So with that, I urge an aye vote. Thank you.
Representative Soper.
Thank you, Mr. Chair, and I also urge an aye vote on this. This is a very appropriate bill to have the petition clause on. A safety clause is for the health, safety, or welfare, or presentation of budgets for the state. The bill here, as we talked about in committee, we never really identified the problem. And because of that, being able to have a delay on the implementation because this is such a major pivot only makes sense. That if the citizens of Colorado want to challenge this legislation, they have 90 days after adjournment to be able to gather signatures and put it on the ballot. That's only happened twice since 1932, so the risk of this happening, if you're the proponents of the bill, is probably pretty low. But as far as the law is concerned, this is very important to have a petition clause.
Is there any further Representative English.
Thank you, Mr. Chair. Members, I ask for a no vote on this amendment. Thank you.
Is there any further discussion on Amendment L002 to House Bill 1187? Seeing none, the question before us is the passage of Amendment L002. All those in favor say aye. Aye. All those opposed say no. No. The noes have it. Amendment L002, 1187 fails. To the bill. Is there any further discussion on House Bill 1187? Seeing none, the question before us is the passage of House Bill 1187. All those in favor say aye. Aye. All those opposed say no. No. The ayes have it. The House Bill 1187 passes. Mr. Schiebel, please read House Bill 25-1236.
House Bill 1236 by Representative Lindsay concerning the screening of a prospective residential tenant by a landlord.
To the bill. Representative Lindsay.
Thank you, Mr. Chair. I move House Bill 1236.
That is a proper motion. Colleagues, as As we're moving along, just remember, please keep your conversations just a little bit lower or move them to the side. Thank you very much. To the bill, Representative Lindsay.
Thank you, Mr. Chair. It is an honor to serve with you.
It is an honor to serve with you.
Good morning, members. This bill would fix several issues with the law that was passed in 2023, HB 1099, which I was a big supporter of back then, and still am, which sought to save tenants some money by allowing them the opportunity to recycle a recent tenant screening report and avoid paying duplicative rental application fees to have the same background information pulled. While 1099 was an important step toward reducing the financial burden of multiple background checks for renters, it contained practical barriers that has prevented it from achieving its full intent. This bill corrects those issues and ensures that portable tenant screening reports are a meaningful tool for renters across the state. It does this by making these screening reports easier to use, by removing the requirement that they may be provided directly from the screening company. Most screening companies refuse to send reports directly to third parties who aren't the paying customer, which has rendered the original law ineffective. By allowing tenants to provide these reports themselves, the bill ensures that renters can actually benefit from the cost savings. Second, and importantly, this bill allows tenants with housing subsidies to use portable tenant screening reports by clarifying that they are not required to provide credit history which they are legally entitled to withhold. Finally, this bill clarifies that rent debts are considered credit history and therefore cannot be used to deny housing to tenants with subsidies. This policy makes sense. Tenants with subsidies have a guaranteed income source, so using past debts to screen them and deny housing is both unnecessary and counterproductive. We urge you to support this bill to ensure that portable tenant screening reports work as intended and that all renters, especially those with subsidies, have a fair opportunity to secure housing.
Representative Zokai.
Thank you, Mr. Chair. It is an honor to serve with you.
It is an honor to serve with you.
Members, we know that we have an affordable housing crisis in Colorado, and access to affordable rental housing is particularly an issue in this state. Part of that problem is that there are many costs associated with having to submit multiple rental applications, and we have our prospective renters paying duplicate fees for having that same background information pulled. In 2023, this body addressed this problem by providing tenants the opportunity to recycle a recent report. However, that is not working in practice because of strict requirements that were put in place, and we are not living up to our promise. So this bill is providing a bit of cleanup. It is allowing our consumers to provide their own screening reports. It is cleaning up the definition of a portable tenant screening report, and it is adding to the definition of an adverse credit event to include past due delinquent rent payments and collections. And what it comes down to, people of color are more likely to not have a credit score. In fact, 15% of Black and Latino consumers are considered credit invisible. And we currently have a situation in our state where renters, and in particular low-income renters, are draining their bank accounts just to search for housing. I think that it is the responsibility of this body to fix this problem and remove just one of the hurdles that our consumers are facing in trying to find safe and stable housing, and I urge an aye vote.
Representative Lindsay.
Thank you, Madam Chair. It switched while we were talking. We have an amendment, so I move L1 to HB 1236 and ask that it be properly displayed.
All righty, just one moment. Amendment L001 has been moved and properly displayed. Representative Lindsay to the amendment.
Thank you, Madam Chair. This amendment responds to a concern that was raised in committee, brought up by the credit associations. It tightens the definition of adverse credit event under the Rental Application Fairness Act. Specifically, it changes or to and thus defines an adverse credit event as an event that can be reflected in a credit report and might negatively affect someone's credit score. As context, this is because in 2023, the legislature passed SB 184, which prohibits tenants with subsidies from being denied housing based on credit history, score, or adverse credit events. This clears up any confusion as to what constitutes an adverse credit event, which would help people with vouchers access portable tenant screenings and save money. We urge an aye vote.
Is there any further discussion on Amendment L001? Seeing none, the question before us is the adoption of Amendment L001. All those in favor say aye.
Aye.
All those opposed, no. Amendment L001 is adopted. Representative Barone. To the bill.
Thank you, Madam Chair. I come up here, I was in committee for this bill, and honestly, it's another one of those bills that really hurt small business, which is small business landlords. This honestly is one of those things that it's going to put more cost, more time on us landlords to be able to properly vet the people that are renting our properties. Of course, we want to help as many people as we can to be able to live under a roof and be housed in the state, but we also have to protect our own property. We have to protect what we invested in. And most of us invest in this solely to help people out that cannot qualify for a mortgage. We understand that the times are tough and the people cannot qualify for a mortgage. We offer that service to these people, and we happily do it as long as we can protect our interests, as we can protect our investment, our property, and doing this by not allowing us to be able to get a credit application directly from the creditors is not something that, we feel comfortable doing so. It's just one of many other bills that are coming through that have good intention to lower the cost of living. I understand that, but this is the wrong way of doing it. This is just putting the cost to somebody else, putting the cost to the hardworking person, the person that's actually trying to help. This is not helping everybody in the state. It's just going to lower the amount of rentals that's going to be on the market. So, I'm up here speaking against this bill, but I also want to run Amendment L003 to House Bill 1236 and ask it to be properly displayed, please.
All right, one moment.
Move Amendment L003 to HB 1236 and ask to be properly displayed, please.
The amendment has been moved. Amendment L003 has been moved and properly displayed. Representative Barone to the amendment.
Thank you, Madam Chair. So this amendment is pretty simple. It just on page 3, line 18, it's striking including and it's substituting excluding as this bill specifically precludes landlords from being delinquent rent payments and collections. This is exactly the type of info needed to reduce risk. So this includes, allows landlords to be able to see delinquent payments from the people that are intending to rent your property as a form of making a decision if they want to do so. I ask for an aye vote.
Is there any further discussion on Amendment L003? Representative Zokai.
Hold on. Okay, thank you, Madam Chair. Colleagues, L003 is against the intent of this bill. It does the opposite of what we are going for here. It holds that tenants with subsidies can be denied housing based on prior rent debts. That is inappropriate and contrary to the goals of this bill, and we urge a no vote.
Representative Richardson.
Thank you, Madam Chair. Though the intent of the bill may be laudable, the intent of this amendment isn't to deny anybody housing, but to ensure that landlords have a full view of the risks they may be taking when renting a home to somebody. I urge a yes vote.
Is there any further discussion on Amendment L003? Seeing none, the question before us is the adoption of L003. All those in favor say aye. All those opposed, no. Amendment L003 is lost. Representative Richardson, to the bill.
Thank you, Madam Chair. I have another simple amendment. I would move L004 to House Bill 1236 and ask that it be properly displayed.
All right, one moment. Amendment L004 has been moved and properly displayed. Representative Richardson, to the amendment.
All righty, as I said, this is a relatively simple amendment. It just removes the "and collections" point to just delinquent payments. Even though we've kind of wrestled over the previous amendment, something that goes to collections is going to show up on a credit report anyway as an adverse event. And I ask for a yes vote.
Representative Zokai.
Thank you, Madam Chair. We urge a no vote on this amendment for the same reasons that we urged a no vote previously. This goes against the intent of the bill. In this case, this amendment would allow tenants with subsidies to be denied due to debts that were assigned to collection, and specifically is undermining the intent of this bill to allow folks to have housing opportunities, even if they've had a debt sent to collections previously. We urge a no vote.
Representative Richardson.
Again, I do urge a yes vote. This does not go against if the intent of the bill is to provide people housing, which I think we all want to do, then we should not be running legislation in this form, unamended, that puts so much risk on landlords, they're going to get out of the business and there'll be no housing to provide. I urge a yes vote.
Representative Garcia Sanders.
Thank you, Madam Chair. I feel compelled to speak on behalf of the many teachers that are in our area who actually have one rental, two rentals that are their nest egg, that are their retirement supplement. And when we add on laws that make them struggle with collecting payments or finding renters that will actually make sure that they're paying rent, our teachers are put in a position of, wow, this wasn't the nest egg that I'd hoped to have because now I'm trying to figure out how I collect back rent, and I wasn't able to do a full background check, et cetera, et cetera. So I'd really like to safeguard our teachers who are wanting to preserve their small little nest egg rental income. So I urge an aye vote on this amendment because that will help them.
Is there any further discussion on Amendment L004? Seeing none, the question before us is the adoption. Representative Luck. Sorry.
Thank you, Madam Chair. I also rise in support of this amendment. Collections are markedly different than payments. Missing a payment, right, a one-off, being a few days late, being a few weeks late, being even a month late is markedly different than when your trend is in a direction of actually having that debt sent to collections. My concern about this is the same as the colleagues who spoke before me. If we want to advance affordable housing, then we need to encourage people to offer affordable housing, not just to their own networks, but to people who move here, to people they don't know, to people who move into community. But when you increase the risk to this degree, where you don't know if the person that you're allowing to use your product, to enter into a home, will actually pay what they have promised to pay, then you do have a disincentive to open that house up, either to people you don't know very, very well, or at all. Or worse, this bill applies just to those folks who have a subsidy. So the most vulnerable in our communities, the ones who need the housing the most, are going to have the door shut on them from the beginning because landlords are going to say, we don't take those here. We're not going to enter into this space at all with folks who are seeking to rent with the assistance of a housing subsidy. And so now the most vulnerable, the ones who most need these doors open to them, are actually going to have them slammed in their face. Collections is a degree higher than payments. If you get rid of the collections piece, at least then the landlord has some comfort or understanding that who is applying may have missed a payment or two here or there, but they don't have a tendency to not pay over the long term and therefore be a greater risk. And so perhaps you will open up more homes if you would just accept this amendment. Thank you.
Is there any further discussion on Amendment L004? Seeing none, the question before us is the adoption of Amendment L004. All those in favor say aye. All those opposed, no. Amendment L004 is lost. Is there any further discussion on House Bill 25-1236? Representative Richardson.
Thank you, ma'am. I would move L006 to 1236 and ask that it be properly displayed.
Amendment L006 has been moved and properly displayed. Representative Richardson to the amendment.
Thank you, Madam Chair. For those of you that I'm sure have studied this bill very carefully would recognize that at the bottom of page 3 and leaning into page 4, there was quite a bit of language that was struck. This language is very important to landlords that are making decisions to ensure that they bring in folks that can pay their rent, that aren't going to lead to collections, that aren't going to lead to late or missing payments, that would lead to other folks having to pay more to cover the losses to the landlord. This just puts us back to where we were and allows landlords to make decisions based on good, credible information, really assess their risk, not be forced to push rents up for everybody in order to mitigate risks that they can no longer control. So I do ask for a yes vote.
Representative Sukla.
Thank you, Madam Chair. Well, I sit in on this committee, and I think that all of us, when we were running for office, we all heard the same thing, that the cost of living is too high and the cost of housing is too high. One of the things that was said, and why I believe this is a good amendment, one of the things that was said was that in committee was that everybody deserves a roof over their head. That statement was made. For me, you could also take that further and say that everybody deserves a car. The thing about that it works that I think we have lost in here is that you have to have the landlord and you have to have the tenant. They both go together. If you don't have one or the other, it doesn't work. We cannot continually pounce on the landlords and expect them to stay in business, to provide more housing, and we're going to come to a situation to where we don't have any more landlords, and then we've really got an affordable housing problem. Thank you.
Representative Barone.
Thank you, Madam Chair. I also come here and stand for this amendment. Just keep in mind, please, this amendment helps out the small businesses, landlords, because you have no idea how costly it is to go to collections, how costly it is to us as a business to have to wait for payment that have been promised to us. And we can't make those payments that we need to pay out. And how costly it is to go through any sort of process to get people to pay us or even out of our properties. It is really costly. And it does put a toll on us as a small business to be able to pay our debts. We also have debts. We have mortgage debts. We have utility debts that some landlords cover utilities for their tenants, like including myself. I cover the non-potable water system because I understand that the lawn is my responsibility. I have to cover that watering system for my lawn. I don't intend to have my tenants cover that because it's not their lawn. They're using it, of course, but it's my lawn. I have to cover that. So there are some expenses that a lot of us landlords have to to endure. I also cover garbage disposal, even though the tenants are the ones that are using the garbage, but at the same time, I don't want the garbage to be in the house. So I cover that garbage disposal because I want it to be disposed of properly. So we do have debts, and this helps out the landlord so we can get paid properly, we can get paid on time, and we can cover our debts as well. I urge and I vote. Thank you.
Representative Luck.
Thank you, Madam Chair. This was actually the section that brought me up to the well to begin with, because I was a little confused about what this would then look like. My understanding is that in the bill that was passed last year or 2 years ago, these reports were made portable such that the tenant only had to pay one time for the application fee, and then they could make it available either directly, they printed out a copy and provided it to the landlord, or they gave the landlord access to the, I just want to make sure that my understanding is correct. So my understanding is that the bill last year, 2 years ago, said we don't want these tenants to have to pay multiple fees for this, and so we allow them to do it once, and then they can make that portable such that they either can print it out and give it to the landlord. But under this provision, the landlord could say, I actually want to see it directly from the credit reporting agency, so give me access somehow to see it direct from them so that I know it's not been doctored or otherwise impacted. So if that's a fair understanding, then if we leave this language and don't adopt this amendment, then your bill would say that the tenant is not required to show the original, but they would just have to show the original on like the actual website or what have you, right? As opposed to a document version that they printed out and gave. Is that a fair understanding?
Representative Lindsay.
Thank you, Madam Chair. The problem with that is that when the way that the statute was written in 1099 is that when people went to find a report that they could even take, there are no reports commercially available that contain all the information that is required under 1099. So there's a problem there of people being able to even get that portable report. And so that's part of the problem. What this does is that in the implementation of this law, we're also seeing that those credit reporting agencies don't allow for you to get your own report and then share it with a third party. So all you're left to do is have the printout that you would get from the website and take it to them. And that's what this bill allows folks to do. And just to be clear, in 1099, there was a carve-out that if landlords don't want to accept a portable screening report, they are still allowed to do their own background check, but then they are only allowed to accept one fee at a time from an applicant so that they're not collecting 10 applications and collecting the money for 10 fees at once. And so they have to go through it one applicant at a time so that people aren't needlessly paying this application fee. So that still exists as a way for them to go through this screening process if they don't want to accept a portable report.
Representative Luck.
Don't sound so excited, Madam Chair. Thank you, Madam
Yes.
Chair, and thank you for that answer. That is very helpful. If I can summarize sort of in my own words, you're trying to comport the law with actual practice, what is available to actually do out there in the world. Yes, she says yes. Thank you.
Representative Barone.
Thank you, Madam Chair. I did hear Lindsay about the whole collecting one at a time for credit checks, but you have to understand too that makes the landlord's process of putting somebody in their home or their property that much longer. To be able to collect multiple ones to decide which one is going to be a good fit, it makes it shorter for us to go ahead and get that person in there and be able to get paid and pay our debts to that property as well. If we take it one at a time, we're going through the application process, there might be some things that fall through the cracks that, maybe we missed something on this tenant and that we should have caught and it was too late. They're already in, they signed the agreement, or it might go the other way to where we push away somebody that was actually good and actually needed the property. This is just for us to get people to come in.
Representative Lindsay.
Thank you, Madam Chair. Thank you for the question, Rep. Barone. That piece of this whole puzzle is part of 1099, which passed in 2023. So we're actually not changing anything about that in this current bill in 1236, but that was put in 1099 because there are cases where sometimes landlords collect many applications at a time, many of those fees, and they don't actually end up using all of those fees to pay for credit reports. So those potential tenants are forking over money and not even having their background checked. And so this is a way so that people, potential tenants and renters, are saving money and not just needlessly forking over this money for the background checks. But it's also not contemplated in 1236. It's already done in 1099.
Representative Barone.
Thank you, Madam Chair, and thank you, Representative, for clearing that up. The one thing that I do, and honestly, I had no idea about 1099 as a landlord myself. I didn't follow that as much, but the one thing that I do is in my application for rental, I do collect the money for a credit check, but I specifically say if I do not run your credit check or you do not get the property, you get your money back. So the only person that actually pays for the application is the person that gets the property and lives into the property. If I don't do that, they get their money back.
Representative Lindsay.
Thank you, Madam Chair. Kudos to you, Rep. Barone. That's awesome. Not everybody does that, so that's why we had to codify it in 1099. Thank you.
Is there any further discussion on Amendment L006? Seeing none, the question before us is the adoption of Amendment L006. All those in favor say aye. All those opposed, no. Amendment L006 failed. Is there any further discussion on House Bill 251236? Representative Kelty.
Thank you, Madam Chair. So, first I want to point out that if reports that are required for renters weren't available, then there would be no renters. So obviously they are available. But yet with this bill, yet another bill to shut down the rental market. One of my previous renters, I'll just give you a little story. I thought, oh, I don't need a property manager. I'll go ahead and handle things myself. And I didn't do a background check. Didn't ask for a credit report. Didn't do the due diligence that should be done by everyone who's renting out their home. And then all of a sudden, now I've got someone who is not paying rent, going 9, 10 months, trying to get them evicted. And when the attorney that I had on my case finally did a background check, did a credit check, found years of bad credit. Now, had I known that, had I actually done the right thing to begin with and got the credit report, got the credit checks that really are actually you should get, it would have saved me thousands and thousands of dollars, especially after I did about $65,000 of damage to my property. With bills like this, no way would I or could I ever advise anyone to actually rent in the state of Colorado. It's just chipping away more and more of the landlord and property owner's rights. They'd be almost out of their mind anymore to even want to rent because there's no protections for them. And now you're taking away yet another protection that they have before they even let their property get rented out by either a scammer or someone's got bad credit or been to collections a million times. Property owners need to have protections, and this is what helps them. I know because I didn't do it, and it totally bit me. So go ahead. Continue your barrage on the rental market in Colorado. Attack rental owners and homeowners and property managers. And you know what? You will, with your vote, continue to destroy the rental market and housing affordability in Colorado, which is already at a critical level. I was elected by my people, by my constituents, to help make things more affordable in Colorado. This will do the exact opposite. You'll be telling your constituents whether you care or not about affordable living and that includes the rental market in Colorado. They'll see with your vote on this bill, and I'm telling you right now, they are not going to like it. I know my constituents do not like this bill. I know I do not like this bill, and this is going to hurt Colorado and its affordability, no matter what. Full stop.
Representative Lindsay.
Thank you, Madam Chair. I just want to reiterate that it is already current law that folks with vouchers or subsidies do not have to disclose all of this credit information as they're applying for places. That's already established. This bill just makes it so because under the two pieces of portable tenant screening doesn't match with the requirements for those with subsidies. So this bill is saying those folks who already go through the process of subsidies are able to use the portable tenant screening. And just so you know, people who are on subsidies or vouchers have already been vetted through the housing department. They've gone through the application process there, proven their income, and that housing authority has agreed they have a certain amount that they will be paid, that their rent will be paid to the landlord. In some cases, it's 100%. And these things go directly to the landlord. It doesn't go to the tenant for the tenant to then pay the landlord. So this bill doesn't take away any landlord's right to be able to see what is already under law, a report for those folks with subsidies and vouchers. Everybody else who's coming just with a regular credit report, landlords are able to see that. That piece is only for folks with subsidies and vouchers, and that's already established in law.
Representative Kelchi.
Thank you, Madam Chair, and I completely, absolutely disagree with that. Matter of fact, even in the bill summary, it says, the bill amends the definition of portable tenant screening report. And it says that a prospective tenant using a housing subsidy is not required to include a credit history report, a credit score, or an adverse credit event with a tenant screening report. And as we know, time goes by, there's always time for them to have bad credit, to actually show credit history. That is, I absolutely, completely disagree that this does not hurt the rental market, that this does not hurt the way that people will go along and try to find good renters. This will absolutely hurt affordability in Colorado. Thank you.
Representative Lindsay.
This is the last time I'm coming up. Thank you, Madam Chair. I just want to be very clear what our bill does. Under current law, folks with subsidies and vouchers already do not have to disclose that information. Under 1099, when people use a portable screening report, they do. So that conflicts with them not having to report it and using a portable tenant report. This just merges it and says that folks who already do not have to disclose this information are also able to use the portable tenant screening report. It doesn't change any piece other than that. And so I would encourage a deep read of the bill. I just don't want it misrepresented that we are making it so that people don't have to disclose anything across the rental market when they're applying for apartments. That is not the case, and I just want that to be stated. Thank you. We urge an aye vote on the bill.
Representative Kelchi.
Thank you, Madam Chair, and I have read the bill. I have read the bill, and it says, so basically, the people who get portable tenant screening reports, it's being said that they want to be included into not getting credit reports for landlords. Let's look at the bill. Rental and credit history reports for the prospect of the tenant that complies with Section 3812-904 concerning a landlord's consideration of a prospect's tenant's rental history, except that a credit history report and a credit score or an adverse credit event is defined in Section 3812-904, is not required to be included in a portable tenant screening report concerning a prospective tenant who is seeking to rent with the assistance of a housing subsidy. So again, right now they have to provide this information. You're saying that now they won't have to provide that information. Anything that helps an actual landlord or a property owner, a homeowner from renting out their home, they need all the information they can to make a wise financial decision for their rental, their home. This will remove that. This will say, oh, they don't have to do it. The others may not have to as per law, but which I disagree with that. But for God's sake, at least let the landlords and the people who are renting their homes to be able to have some sort of tool in their chest to be able to make wise decisions. Again, this is going to hurt affordability in Colorado. Full stop.
Is there any further discussion on House Bill 25? Representative Richardson.
Thank you, Madam Speaker. Just want to, for those that weren't in committee, this did come out on a 7-4 vote. 3 of those that voted yes indicated they had concerns. There were some confusions as to what this bill was trying to do and how it was implemented. I'd remind those 3 people that you all said that you looked forward to the sponsor continuing to work on the bill and making it right. What we did today with L001, one of 6 amendments that was actually adopted, was fix a typographical error. That does not fix the structural problems with this bill. But I just want to share with you something we did hear from a housing provider, a small businessman. And just a brief quoting here, one of the most important protections for housing providers, and I've lost my place. One of the most important protections for housing providers in ensuring they place qualified and responsible tenants is through an application process that includes an accurate, timely, verifiable screening report. The ability to obtain a portable tenant screening report directly from a reputable third-party consumer reporting agency is essential to ensuring the accuracy and integrity of the information used in rental decisions. Without this safeguard, there's a significant risk of fraudulent or altered reports. And the sponsor did speak to the fact that, well, if you can't get it directly, you can print it off and give it to them. There are folks that provide housing that are rightly concerned that in these days of AI and, that you can create any document that you want. So a verified third-party source ensures compliance with state and federal laws and helps housing providers make informed decisions that promote stable, successful tenancies. Stable, successful tenancies is what we want. We want to reduce folks being evicted from apartments. We want people to have housing. That's the one thing we all agree on. So it's important to recognize, he goes on, that an accurate screening report is a safeguard for current residents living in the same building or nearby. Again, it kind of helps keep renter low. Not everyone is a good fit for potential housing, particularly if there's adverse conditions reported, such as prior evictions or criminal history that could pose a risk to other tenants. This isn't just about whether one person deserves to have a place to live or given to him at great risk to a landlord, but actually preserving the safety of other residents. So I urge a no vote.
Representative Bottoms.
Thank you, Madam Chair. I think this is a good teaching moment, a good explanation moment. We continue to do these kind of things in the House, and I understand that some of the argument that is being made by the sponsor is, well, some of this is already in place. Well, this is a good moment to say this. It shouldn't be in place. These are bad policies that are attacking our housing across the board, and we say, well, yeah, but it only attacks, the evil landlords. Except that when you attack evil landlords, you're taking houses off the market, you're raising cost, and so you're attacking the people that need to be in these homes. You're attacking people in the process. When you keep information from landlords, when you keep information from property owners, you are hindering the entire process, because now there's another layer of government intrusion that places distrust within the housing market. How do you know who is renting your property? How do you know who is buying property? How do you know any of this stuff? When we keep adding layers and layers and layers, which we've done quite a bit over the last couple of years, we keep adding layers and layers that do one major thing. It keeps driving up cost. Everyone is hurt in the process. It keeps limiting the housing market overall with one more slice and one more slice and one more slice. Well, this bill is another slice. The government needs to get out of this arena and stop trying to control the market, stop trying to control property owners, stop trying to control the people in the process. You're hindering people from having a roof over their head. When you do these things, you're hurting the people that need a place to live. And we think about it, I don't think about it this way. I see the big picture, but you say, no, we're going to hurt all the people that are making just loads and loads of money on this. The average property owner is barely skimping by, and as one of my colleagues testified to, they're having to put all kinds of extra money into this. I did this years ago, and there's all kinds of things that it appears, from my point of view, that the left side of this is not paying attention to any of the actual market forces that are determining all of these elements, specifically rent, housing costs. The left seems to be like there's this big bucket of money that all of these property owners have, and they don't. And you're hurting the overall thing by continuing to add another layer of government intrusion, another layer of government intrusion. We've got to stop stacking these hindrances upon hindrances upon hindrances, and somewhere we've got to take back what used to be a state where people could afford to live. We're not that anymore. We need to stop this, and we need to reclaim Colorado.
Representative Zokai, or Representative Barone. Okay.
All right. Whatever.
Representative Zokai.
Thank you, Madam Chair. This bill is not attacking anybody. It is removing a barrier that is facing low-income renters. And I think it's funny how we all talk about the affordable housing crisis and that we all talk about how we should do everything in our power to address the cost of living until that comes to supporting renters. I think it's funny that when we talk about supporting low-income renters, we're attacking landlords. And I think that there are good landlords in this state that want to support our renters and that they see that this is an obstacle that they are facing. This bill is simply about the fact that we have renters facing a barrier of the costs associated with having to submit multiple applications and paying duplicate fees for the same background information. It is not barring that information from being shared. It is removing a barrier for having to pay that fee over and over again. We shouldn't have our renters drain their bank accounts just to apply for housing. So we are making it easier for them to apply. That is all this bill does. And I think that we have gone way off base in our discussions. This body had the intent of fixing that problem, and when our intent is not being realized, we have a responsibility to fix it. So we are providing those fixes. I urge a yes vote.
Representative Barone.
Thank you, Madam Chair, and thank you, Representative Sokai, for clearing that up. But I am going to go back to your original intent of making it easier for renters. Yes, it does make it easier for renters at the expense and at the risk of landlords, small business landlords. This is really a risk that us as small business landlords cannot afford to take. We cannot afford to streamline the process that's really making it easier for us to be able to rent our properties to the right person that will pay on time, the right person that will take care of our properties. We're not asking for praise for doing this for them, but we are asking for them to take care of our properties. This is a risk, a bill that's going to risk our investment, that's going to risk what we're doing here for them, just to make it a streamlined process for anybody to come in. That's what we're arguing here today, and that really is, in my opinion, an attack on the small business landlord because of that fact that we're taking that risk to streamline a process. You don't streamline the background check of anything else, just because you want to make it easier for them, you got to make sure it's going to be done right. So that being said, I want to move Amendment L005 to HB 1236 and have it properly displayed, please.
One moment. Amendment L005 has been moved and properly displayed. Representative Barone to the amendment.
Thank you, Madam Chair. So this amendment basically just takes the effective date back to January 1st, 2026. I urge an aye vote. Thank you.
Representative Sokla. Yeah.
Thank you, Madam Chair. I believe that the sponsors have big hearts, and I believe that they want to do what's the best. I would seriously look at this amendment just in the fact that in committee, we had 3 people that say that we are yes for today, meaning that the bill needs some cleanup. So I would urge an aye vote on this amendment.
Thank you. Representative Sukla. Sorry for pronouncing your name wrong. Representative Zokai.
Thank you, Madam Chair. So this amendment is pushing the effective date back to January 2026. And we do not see the logic to requiring people to continue to struggle to afford their application fees. We're just prolonging this problem for longer than necessary. And it truly, there is no reason to have this delay. We have done our stakeholding, we have offered amendments. This bill is ready to be implemented, and there is no new obligation on landlords, so there is no reason to push this out further. We urge a no vote.
Is there any further discussion on House Bill 1236? Seeing none, the question before us is the adoption of House Bill 1230. Oh, wait, I'm sorry. I got ahead of myself. I was trying to get through it. I will withdraw that. The question before us is the adoption of Amendment L005. All those in favor say aye. All those opposed, no. Amendment L005 is lost. Is there any further discussion on House Bill 1236? Seeing none, the question before us is the adoption of 1236 as amended. All those in favor say aye. All those opposed, no. House Bill 1236 as amended passes. Mr. Shebo, please read the title of House Bill 1290.
House Bill 1290 by Representatives Lindsted and Valdez, also Senator Mullica, concerning transit worker safety.
Representative Lindsted.
Thank you, Madam Chair. I move House Bill 1290 and the committee report.
To the committee report.
In the committee, we added some language on behalf of the defense bar to add reasonably to the definition and clean up the statute so that it didn't include indecent exposure. We also added Amtrak workers to the bill, and we clarified language on the Prop 130 piece in Section 2. I ask for an aye vote.
All right. Representative Bacon. I'm sorry, Assistant Majority Leader Bacon.
Thank you, Madam Chair. I would just like to put on the record some questions that I have on House Bill 1290, including what's in the committee report. Sorry. I do want to point out what looks like it was added in the committee report on the first page, lines 11 through 16. There is reference to Prop 130. And the concern that I have is we have not decided as a legislature yet how we would like to approach Prop 130. And I do believe there are still questions outstanding to interpretation to figure out the scope of Prop 130. And so if this is in response to RTD being left out, I do believe we need to check to see on either why or if they can be added back in. And so I do have a question about that. I'm not sure, and this is for me personally, if I feel like this is an appropriate place to put any statements about Prop 130. And I think as well, in regards to some other components of the bill, I just want to be sure. Actually, I'll stop there on the committee report. So the concern on the committee report is, and again, wanted to put on record, we have not made determinations on Prop 130 yet, and there are still outstanding questions in regards to what can be included. So I'm just a little leery of putting it into a bill before we've made those determinations.
Representative Valdez.
Thank you, Madam Chair, and thank you, Assistant Majority Leader. I think what we're doing here is the voters anticipated spending on areas of public safety through the county and city governments. RTD is unique. It does have a police department, a full-fledged police department, but it's part of a district instead of a county or a locality. So we want to make sure that it's seen that way when they do get to the point of working with those funds, and we think it's important that that police department be recognized when those funds are given out.
Representative Armagas. And this is to the committee report.
Thank you, Madam Chair. The argument I'm hearing is about the Prop 130 money versus opt-in for local governments. Prop 130 money already went to the people, went to the vote, and the people have spoken and determined how they wanted that money to be spent. So I think I'm in full agreement with how that portion was taken out of the bill, where we are making this simply a local government opt-in. That can be something that the people can agree on for their local governments, but the people already did agree on the fact of where they wanted that Prop 130 money to go, and this isn't it. So I support that, and I think that needs to stay the way it is.
Representative Barone.
Thank you, Madam Chair. I was in the committee for this hearing, and I just want to double check and double make sure of my question that I had in committee that was answered, but just in case, I know they're going to try to get Prop 130 funds, but just in case they do not get the Prop 130 funds, I want to make sure that the state will not be on the hook to pay for this program, just because the Prop 130 funds doesn't go through. The fiscal note does show that. It shows a zero fiscal note to the state, and I want to make sure it stays that way if the Prop 130 funds don't come through.
Is there any, Assistant Majority Leader Bacon?
Thank you. One last point on the committee report and the language in regards to the assault. I'm now looking at lines 5 through 9. The only question I have for the sponsors, if they intend to exclude from the crime the assault because of the added language. So material incidental contact by transit worker with fluid or material for the purposes of cleaning and so forth is not an assault in the third degree. And so I just want to be clear that we're saying it's not an assault at all. That is my understanding. I just am curious if that could be cleared up.
Is there any further discussion on the transportation? Representative Carter.
Thank you, Madam Chair. Thank you, Madam Chair. I would like to move L5 to the committee report and have it properly displayed.
One moment.
Sorry.
Amendment L005 has been moved and properly displayed. Representative Carter to the amendment.
Thank you, Madam Chair. Members, this amendment would strike Part C and Part D of this specific bill. We, at this point, this body believes it only has one way to deal with issues. It only has one ability to deal with issues, and that ability is to increase or create additional crimes. This is exactly what this bill already does. The reality is everything within this bill is already a crime. All it is doing is heightening a specific party or a specific group and criminalizing at a heightened level what is already a crime. At a certain point, we as a body have to decide what we're going to do and how we're going to fix our problems. And we as a body have to decide why the answer is always more crimes. I'm requesting this amendment, and I'm asking for a yes vote.
Representative Mabry. To the amendment.
Thank you, Madam Chair. Members, I have a lot of concerns with this legislation. I first want to say that I think it's unnecessary. We have criminal statutes to cover assault already. Also, if you ride RTD, which I often do, there's a big sign in the bus right behind the driver that says if you touch the driver, if you harass the driver, if you assault the driver, you're going to be subject to jail time for up to X amount. I think it was a year. You're going to be subject to Y fine. And so the idea that this is going to add an additional deterrent is a little bit ridiculous to me when there's already right there on the bus behind the driver information about you being able to spend a year in jail if you commit assault on a driver. Now, I agree, if you commit assault on a driver, you should face penalties. That does make sense, but this unnecessarily heightens that penalty in a way that I am worried will further burden Colorado's already overburdened competency system. We have a mental health crisis in this country. People who have severe mental health issues cannot find treatment. And that means a lot of them are left wandering the streets and unhoused with nowhere to go. And that means that they're more likely to be on public transit. And as a result of that, our public transit workers are, because we have not invested enough in mental health. They are on the front line dealing with our mental health crisis. And we should recognize that. And they should be paid adequately to address that. But if we are creating an additional penalty here and having these people with severe mental health issues face jail time, we need to think about the burden that that has on our competency system. Because if multiple times you're doing something like harassing a bus driver or spitting on a bus driver, of course, you should be charged with assault. But if we're getting people more justice involved, if you are doing these things multiple times, you are likely not competent to stand trial. You likely do not have the capacity to know where you are. That's why you're committing these crimes. And so I have serious concerns with this part of the bill, the part of the bill that this amendment addresses, because I feel that it is creating an additional penalty on something that is ultimately a symptom of mental health. I agree that this is a problem that we should address. I think that we should address this problem by getting people the care that they need. I do not think that we should address this problem by creating additional penalties. I also talked to proponents of this legislation and asked them about trends in this area. And I didn't get any information that between last year and this year that this is an increasing problem. I remember I actually spoke to the folks from RTD my first year, and they said, hey, this is the problem. This is a problem that's preventing us from hiring people. And then I met with them this year, and they said, hey, like, we've hired so many new drivers. We've almost closed the gap. Well, I thought this was the burden on them hiring folks. And so I need to see information on this being a trend. And, you know, I think that this is an issue that deserved thoughtful discussion in the committee that deals with crimes. This did not go to the committee that deals with crimes. And so with all of that, I will urge a yes vote on this amendment.
Sorry. Representative Valdez.
Thank you, Madam Chair. So first of all, we understand there's a mental health crisis out there, but we also understand it's not the operators of our public transportation that need to bear the brunt of it. I just want to let you know, in New York and Washington State, this was made a felony. What we're doing here is we're creating really a separate category so that we can do a few things. We can let people know when they enter a bus that they are committing a special crime when they go after the person who's operating the vehicle that may potentially be carrying your family members. And just for some context, I went to school in my past life I went to school to be a pilot. And I never had to worry about this because if you assault and punch a pilot in the face during the operation of their duties, you're going to disappear for a long time. And that's because it is a hazard to the safety of the other people that are riding on that conveyance. So while we understand that there are other issues, we also understand that we don't want those things to fall upon our operators. We would ask for a no vote on the amendment. We're happy to continue conversations going, and we would ask for a no vote.
Is there any further discussion on Amendment L005? Representative Carter.
Thank you, Madam Chair. Call for a division.
All right. A division has been called. Read it. Okay. The question before us is the adoption. I'm sorry, I'm holding up. The committee will stand in a brief recess. Thank you. The committee will come back to order. The question before us is the adoption of Amendment L005. A division has been requested. All those in the chamber not entitled to vote, please sit and remain seated. All those in favor of Amendment L005, please stand and remain standing in one place or raise your hand and keep it raised until the count is taken. You may be seated. All those opposed, please stand and remain standing in one place or raise your hand and keep it raised until the count is taken. You may be seated. Amendment L005 is lost. Representative Luck, are we still to the committee report? To the committee report.
Thank you, Madam Chair. My question is as relates to the funding. So you did do some stuff in committee related to the funding section, so I just want to understand that before the committee report is adopted. As I understand it, this $350 million is the $350 million that was approved by the voters in November of last year. If that is true, the Regional Transportation District Transit Police Officers, are they police officers, like post-certified, such that they would have been contemplated in the minds of the voters such that we can be assured that adding them into this funding doesn't go against the will of the voters in November?
Representative Lindstedt.
Thank you, Madam Chair. You know, the amendment we took in the committee was an amendment that we came to with the police chiefs that require that funding to come through the approval of another agency. So we've worked with them to get this to a good place. I think when that ballot measure was passed, some of the crimes and some of the things we have seen on our public transportation here in Denver were in the minds of the voters at that time. So I think yes, but they weren't explicitly outlined in the bill. We came to a good compromise on the language, and I would urge the passage of the committee report.
Representative Luck.
Thank you, Madam Chair, and thank you for that. You've now raised my curiosity around the interaction with the police chiefs, so could you just give me a brief summation of those negotiations and why it was a compromise, like such that I don't understand where they were at, where you were at, and how that then resulted in where we are.
Rep. Lindstedt.
Thank you, Madam Chair. You know, we had a good discussion with all variety of stakeholders on this bill, supporters, opposition, to land in a good place. I know the Prop 130 discussion is still ongoing in the legislature. I think where we landed on this bill is kind of a neutral place at this time, and I know as this bill moves through the Senate, they will be committed to making sure this bill aligns with what the legislature decides to do when it comes to implementation.
Is there any further discussion on a committee report? Seeing none, the question before us is the adoption of the Transportation, Housing, and Local Government Committee report. All those in favor say aye. All those opposed, no. The committee report has been adopted. To the bill. Is there Assistant Majority Leader Bacon?
Okay, members. The place that I'd like to talk about the bill, thank you for some of the discussion, and I do want to apologize for being very judiciary. I know that's what we're doing, and go team, commas matter, okay? But what I'd like to point out on the bill does two things. it adds, in my opinion, transit workers to an assault statute, but it also has language on Prop 130. And, you know, I've already expressed what my concerns were on that. But I'd like for anybody who's paying attention, I think the issue that I'm having with the bill is subpart D, okay? There is already existing in statute an assault crime for what exists in the bill for assaulting a peace officer, a firefighter, emergency medical care provider, or emergency medical service provider, or EMTs. Sub C repeats what already exists and just adds transit workers. So I believe maybe we should have just added transit workers to the existing assault. But the challenge I'm having is sub D, in that sub D says with the intent to prevent a transit worker from doing their job, they have equated that to bodily injury. And bodily injury is an element that is key to assault. That's why you see it elsewhere in the statute about getting hit by fluids. And so the reason why this is important is we have other crimes of obstruction. If you obstruct a peace officer, which we talked about at length yesterday, that is an M2, that's not an M1. So we're making it more severe of a crime to obstruct a transit worker than a peace officer, a firefighter, or an EMS worker. That is my concern. And so what I would have questioned in bringing this bill forward is why we just did not add public transit worker to the list of folks to where assault in the third degree already exists, which includes a peace officer, firefighter, EMS. We added sub D. And so that's what concerns me on that. Everywhere else, impeding or obstruction of jobs is an M2, not an M1. And an M1 is 2 years of jail time. So for me, and you know, the judiciary bug is that we need our crimes with the similar elements to have the same sentencing. We literally spent 12 hours on that yesterday, and that is my concern and questions, and I can't wait.
Representative Luck.
Thank you, Madam Chair, and thank you, Representative from Denver, for this conversation, because I'm with you, and it kind of goes back to my question with respect to the funding as to whether these particular workers do constitute law enforcement, peace officer, do they fall under that? Because one might argue that they already fall under what is already here because they could be considered peace officers. So that would be really helpful to know if we are just duplicative in terms of B and C. With respect to D, though, I just wonder if the representative from Denver thinks that it's actually difference in kind when you are the driver of a bus and someone throws, feces on you while you're driving the bus, such that you are now distracted driver. You are not only putting yourself at risk in that moment or the bodily injury to yourself, but everyone who's in your care on that bus is also now at risk of serious bodily harm. And so the question to me would be, in those other instances that you're mentioning where it's already at law, does it contemplate that sort of situation? Such that, if you're on the street and there's a police officer who you hinder, the impact to the surrounding community could be greater, but it also isn't necessarily greater in every instance. Whereas if you interrupt someone who is driving a train, driving a bus such that they could derail or go off the road, you are actually potentially causing even greater harm than just to that one person. And so does that not then require more, a higher level of punishment?
Sister Majority Leader Bacon.
Thank you for the question. And throwing something at someone is already covered in assault. The other problem says it's lawful duties. That could be, who knows what that is? That could be just stopping. That could be sweeping. So that's why I have these questions, particularly to make it that. And I would also make the same argument for an EMS driver or a firefighter if someone, or anybody in a squad car, but we don't have the same law for that. So, at the very least, we got to have the discussion here about it, but I get your questions, and I would argue throwing of something and something hitting is already an assault, and that is already an M1, so I don't disagree with you on the impact of that. But also I would say that I'm not sure what lawful duties are other than driving, because it doesn't say driving, it says lawful duties. And then when I think about the other folks who are in the same position, I could make the same argument, and yet we do not have a separate subsection for them. So I'm just looking for consistency, and those were my questions on it.
Representative Luck.
Thank you, Madam Chair, and thank you. Actually, when I first heard about this bill, I was concerned similarly with my colleague that we were creating a special class and a special set of protections for a special class, though I do believe that this space has additional layers of risk that maybe don't exist in the EMT space to the same degree, right? If you are in a police vehicle, there's probably some sort of barrier between where the person is and the policeman, similar in many ambulance situations, et cetera. And so I don't know that you're comparing apples to apples, though I do think it's worth the conversation. I also think, though, that this, in my example, probably was not the best example in terms of throwing, because I was conflating C and D, but if someone gets onto a bus and doesn't throw or doesn't meet and satisfy the terms of C, but otherwise prevents the transit worker, let's say, starts to but. So I'm sorry, I should just talk to you guys first and then avoid the conversation over here that is the rebuttal to what I'm saying right now. If, let's say, there was some sort of intentional distraction, whether a shouting or otherwise causing that transit worker to have to refrain from doing what he or she was doing, I do, again, because that person is the steward over every passenger on that transit bus, train, what have you, there should be a higher standard for protecting them and all of the people in their care. And so I don't know that I think that this is not worth pursuing, even if there are arguments for ensuring that other people similarly situated also have the protections, maybe in future bills.
Representative Mabry.
Thank you, Madam Chair. First off, I do want to recognize that the bill sponsors have taken some amendments from the criminal defense bar, and I deeply appreciate that. I just want to come up and reiterate some of the points that I made earlier about how we have assault, right? The things that are described in this bill are already crimes. What I'm alarmed about is creating a second level of crime for somebody who is more likely to suffer from mental illness. That's where I think this is going to land us. And Senator Amable and Senator Weissman and I have worked on legislation in the competency space to address Colorado's competency backlog, and I'm worried that this makes the problem worse, that people who, for whatever reason, are on a bus and think that it's a good idea to spit on or attack a bus driver. That already should be assault. I agree. But if we are increasing criminal penalties and creating new opportunities for people to get more deeply involved with the criminal justice system, how does that impact our competency wait list? And also, again, I haven't heard anything about trends in this space. I'm not sure that this is something that is trending up. In the Judiciary Committee Smart Act hearings, we get reports from the Department of Public Safety on crime rates, and crime is going down in the state of Colorado. And so with crime going down, I'm not sure why we're creating an additional penalty here that is going to create opportunities for people with severe mental illness to get more deeply involved in the criminal justice system. And so while I do appreciate the stakeholding done by the bill sponsors and the bill sponsors as people, I will be a no on their vote on this bill.
Is there any further discussion on House Bill 1290? Seeing none, the question before us is the adoption of House Bill 1290. All those in favor say aye. All those opposed, no. House Bill 1290 is adopted. Mr. Shebel, please read the title of Senate Bill 51.
Senate Bill 51 by Senators Michelson, Janae, and Peltonar, also Representative Lindstedt, concerning the definition of operating costs for calculating cost efficiency metrics for the Regional Transportation District.
Representative Lindstedt.
Thank you, Madam Chair. I move Senate Bill 51.
To the bill.
This bill came from the state auditor, and it updates the definition of operating costs in RTD's statute. It was an important bill, got through the Senate unanimously, and it's to include things like depreciation in RTD's definition of operating costs so that it better aligns with the definition of operating costs nationally. And again, it came from the state auditor. I asked for an aye vote.
Is there any further discussion on Senate Bill 51? Seeing none, the question before us is the adoption of Senate Bill 51. All those in favor say aye. All those opposed say nay. Senate Bill 51 is adopted. Representative Lindstedt. Oh, I'm sorry. Oh, you're on another bill. My bad. Listen, I thought my eyes was playing tricks on me. Mr. Shebel, please read the title of Senate Bill 23.
Senate Bill 23 by Senators Peltonar and Michelson, Janae, also Representative Lindstedt, concerning local government audit exemption thresholds.
Representative Lindstedt.
I move Senate Bill 23.
To the bill.
Thank you, Madam Chair. I just figured I would clear all of my bills in 1 week this week here in the House. Senate Bill 23 is also from the state auditor, and it increases local government audit thresholds as a result of the work the state auditor did over the summer. So we haven't updated these numbers since the 90s. It's time to move them up. Good bill. Vote yes.
The question before us, is there any further discussion on Senate Bill 23? Seeing none, the question before us is the adoption of Senate Bill 23. All those in favor, aye. All those opposed, no. Senate Bill 23 is adopted. Mr. Shebel, please read the title of Senate Bill 14.
Senate Bill 14 by Senator Danielson, also Representatives Garcia and Tatone, concerning repealing the statutory unconstitutional ban on same-sex marriage.
Representative Tatone.
Thank you, Madam Chair. I move Senate Bill 14.
To the bill.
Thank you, Madam Chair. This bill is very simple. It strikes out the statutory provisions still in statute that says same-sex marriage is illegal. We're striking this out. Recently, Amendment J said we wanted that out of our Constitution, and the people overwhelmingly said yes to remove that. We're finishing the job removing this. I ask for a yes vote.
Representative Garcia.
Thank you, Madam Chair. I also ask for a yes vote.
Is there any further discussion on Senate Bill 14? Seeing none, the question before us is the adoption of Senate Bill 14. All those in favor say aye. All those opposed, no. Senate Bill 14 is adopted. Mr. Shebel, please read the title of Senate Bill 67.
Senate Bill 67 by Senator Simpson and Roberts, also Representatives Martinez and Winter, concerning changes to the Prosecution Fellowship Program.
Representative Martinez.
Thank you, Madam Chair. We move Senate Bill 67 and the, just the bill?
Just moving the bill?
And we move Senate Bill 67.
To the bill.
We would like to move, I move L1 and to Senate Bill 67 and ask that it be displayed slightly to the left.
One moment, please. Amendment L001 has been moved and properly displayed to the amendment. Representative Martinez.
Thank you, Madam Chair. So this came out of committee to making sure that we are applying to only regionally accredited institutions. This came up in committee. We wanted to add an amendment as promised to making sure that we are keeping out those that are not accredited or not regionally accredited institutions out from participating in this program. So we requested an aye vote.
Okay. The committee will go into a brief recess. The committee will come back to order.
Thank you,
Representative Winters to the bill.
Thank you, Madam Chair. We'd like to withdraw Amendment L001.
The amendment has been withdrawn. Representative Johnson to the bill.
Thank you, Madam Chair. I was a part of the committee and was a strong yes vote because we have rural counties. 47 fall into this definition out of the 64 that would benefit from this program. We in rural areas have less population, but we have the exact same needs. We heard amazing testimony from DAs across the rural areas of Colorado who very simply said, if this bill does not go through, then they're going to lose some of the staff that they need. Now, they'll still do the work, but the way they explained it was you can have more staff and do a lot more due diligence. You can do a lot more efforts. You can meet with different folks on different trials for 20, 30 minutes up to an hour. Without that extra staff, though, you don't get that extra care that needs to be happening in a lot of these lawsuits. Very much that we need to make sure that we're treating all of our suits, be it the victims, be it the alleged, with as much care and due diligence as possible. But it's very hard to do in rural Colorado when we're lacking the personnel to do it, which is why we had many DAs come forth and say, we need this in rural Colorado because we're losing folks to metro areas. We're losing very applicable students and DAs going to metro areas because there are more resources there. There were jokes made that when you live in rural Colorado, you want to take, maybe your spouse to go shopping because we do not have the resources. There were other jokes saying, if we want people to stay in rural Colorado, you marry a farmer. Well, with this bill, it opens up the ability that they can learn, they can have that expertise, they come and get the resources they need. Should they want to marry a farmer, they still can, but they'll stay for other reasons as well. They also then get more resources, so we're making sure our judicial system is operating at its top-notch best, like all of our DAs, prosecutors, lawyers, etc. want to do. But in order to do that, you have to have all the support, so I'm a strong yes vote.
Representative Martinez.
Thank you, Madam Chair. I move Amendment L2 to Senate Bill 67 and request that it be displayed slightly to the right.
One moment. Amendment L002 has been moved and properly displayed. Rep. Martinez to the amendment.
Thank you, Madam Chair. So, as previously stated, this adds regionally accredited institutions into those law schools that are participating in the program. We request an aye vote.
Is there any further discussion on Amendment L002? Seeing none, the question before us is the adoption of Amendment L002. All those in favor say aye.
Aye.
All those opposed, no. Amendment L002 is adopted. Representative Martinez to the bill.
Thank you, Madam Chair. This bill is good for rural Colorado. I won't repeat what my colleague from the Eastern Plains has said already, but I will just say that getting rural prosecutors into district attorney's offices and making sure that we provide them as some assistance is good for rural Colorado, which is better for the entire state. We urge an aye vote.
Assistant Minority Leader Winters.
Thank you, Madam Chair. I appreciate that. I like to echo what my colleagues say. This is definitely a rural Colorado issue. This is something that I've heard about for the 3 years that I've been here when I go into district is it's hard to recruit these individuals based on a lot of things. And one of them is competitive salaries. And I think that it's really important that we allow the DAs to be able to use this fund in whichever way they see fit to bring people into our communities. And with that, I urge an aye vote.
Is there any further discussion on Senate Bill 67? Seeing none, the question before us is the adoption of Senate Bill 67. All those in favor say aye. All those opposed, no. Senate Bill 67 is adopted. Mr. Shebo, please read the title of House Bill 1222.
House Bill 1222 by Representatives Winter and Lukens, also Senators Roberts and Simpson, concerning measures to preserve health care access provided by rural independent pharmacies.
Representative Lukens.
Thank you, Madam Chair. I move House Bill 1222 and the Health and Human Services Committee report.
To the committee report. Representative Lukens.
Thank you, Madam Chair. I move L11 to the committee report and ask for it to be properly displayed.
Amendment L011 has been moved and properly displayed. Representative Lukens to the amendment.
Thank you, Madam Chair. This is a technical cleanup requested by the drafter. We ask for a yes vote on L11.
Is there any further discussion on Amendment L11? Seeing none, the question before us is the adoption of Amendment L11. All those in favor say aye. Aye. All those opposed, no. Amendment L11 is adopted. Rep. Lukens to the committee report.
Thank you, Madam Chair. I move Amendment L14 to the Health and Human Services Committee report and ask that it be properly displayed.
Amendment L14 has been moved and properly displayed. Representative Lukens to the amendment.
Thank you, Madam Chair. L14 is coming to you after further stakeholding on the CPI component of this bill and the rural independent pharmacy dispensing fee. This amendment will ensure an annual 1% adjustment to account for inflation, and we ask for a yes vote on L14.
Is there any further discussion on Amendment L14? Seeing none, the question before us is the adoption of Amendment L14. All those in favor say aye.
Aye.
All those opposed, no. Amendment L14 is adopted. Rep. Lukens to the committee report.
Thank you, Madam Chair. In the Health and Human Services Committee, we brought a number of substantial amendments to this bill. There were amendments to clarify a number of issues addressing reimbursements, as well as the legislative declaration, as well as there were ongoing conversations about dispensing fees, and we ask for a yes vote on the Health and Human Services Committee report.
Is there any further discussion on the Health
As
and
amended.
Human...
Sorry. As amended. Sorry.
Okay, is there any further discussion on the Health and Human Services Committee report as amended? Seeing none, the question before us is the adoption of the Health and Human Services Committee report as amended. All those in favor say aye.
Aye.
All those opposed, no. The Health and Human Services Committee report as amended is adopted. Representative Assistant Minority Leader Winters to the bill.
Madam Chair. I would like to move Amendment L013 and ask that it properly be displayed.
Amendment L13 has been moved and properly displayed. Assistant Minority Leader Winters to the amendment.
Thank you, Madam Chair. This amendment will essentially strike the geographical component of the rural independent pharmacy definition. This will ensure that only independent pharmacies are under this definition, protecting the definition and the narrow scope this bill intends to have. And I urge an aye vote.
Is there any further discussion on Amendment L13? Seeing none, the question before us is the adoption of Amendment L13. All those in favor say aye.
Aye.
All those opposed, no. Amendment L13 is adopted. Assistant Minority Leader Winters to the bill.
Thank you, Madam Chair. I ask to move Amendment L015 and ask that it properly be displayed.
Amendment L15 has been moved and properly displayed. Assistant Minority Leader Winters to the amendment.
Thank you, Madam Chair. This amendment simply adjusts the applicability date for Section 4 of the bill. The remaining components of the bill will be implemented 90 days following adjournment. And with that, I urge an aye vote.
Is there any further discussion on Amendment L15? Seeing none, the question before us is the adoption of Amendment L15. All those in favor say aye.
Aye.
All those opposed, no. Amendment L15 is adopted. Representative Lukens to the bill.
Thank you, Madam Chair. Members, we are very excited to bring House Bill 1222 today, which preserves healthcare access through rural independent pharmacies. This bill supports our independent pharmacies, which are in crisis. It will ensure fair reimbursement. By protecting access to essential medications and healthcare services, especially in rural and underserved vulnerable communities, and it will preserve the pharmacy marketplace, promoting competition, lower prices, and better care, and it will save long-term healthcare costs by supporting community-based services that prevent more expensive health interventions. I also would like to note something that came up in committee. And this question came up in committee around the definition of rural independent pharmacies. And so the question was, will this bill impact only rural pharmacies, or will it impact independent pharmacies across the state? And the answer is this bill will impact independent pharmacies across the state. Based on the amendments that we just put into this bill, as well as the amendments that we put on in committee, the definition says rural independent pharmacy means a prescription drug outlet that is privately owned by at least one licensed pharmacist with no ownership interest by or affiliation with a chain pharmacy or a publicly traded prescription drug outlet. So for those of you that may not live in rural Colorado, but you want this bill to apply to your districts, it still will, based on this definition of, even though we are saying rural independent pharmacy, it means if a privately owned by at least one licensed pharmacist with no ownership interest by or affiliation with a chain, then this bill applies to the pharmacies in your district. I ask for a yes vote on House Bill 1222.
Assistant Minority Leader Winters.
Thank you, Madam Chair. Members, this bill's been a labor of love. I've started this process, I guess, late summer, and it's really important. I mean, independent pharmacies are huge, and you're correct. The buying power of independent pharmacies is tied to rural pharmacies, and it's important that we kept that component in the bill. The other thing about this bill is our pharmacies in rural Colorado, they're also somewhat healthcare centers. The pharmacist in Rocky Ford talks all the time about how the doctor sent him over for flu tests and other testing that is done. And they also have a small storefront. It's important to keep these pharmacies alive. Like I say, we talk about healthcare deserts all the time. Rural Colorado faces one of the largest healthcare deserts there is, and this is great access to make sure that, not only that our constituents to get to these pharmacies, but these rural independent pharmacies are still there for them at the end of the day. And with that, I urge an aye vote on 1222. Thank you.
Is there any further discussion on House Bill 1222? Seeing none, the question before us is the adoption of House Bill 1222. All those in favor say aye. All those opposed, no. House Bill 1222 is adopted. Sorry. Majority Leader Duran.
Thank you, Madam Chair. I move the committee rise and report.
You have heard the motion. Seeing no objection, the committee will rise and report.
The House will come back to order. Mr. Shebel, please read the report of the Committee of the Whole.
Madam Speaker, your Committee of the Whole begs leave to report as under consideration the following attached bills, being in the second reading thereof and making the following recommendations thereon. House Bills 1187 as amended, 1222 as amended, 1236 as amended, and 1290 as amended, passed on second reading, ordered and grossed and placed on the calendar for third reading and final passage. Senate Bills 14, 23, 51, and 67 as amended, passed on second reading, ordered revised, and placed on the calendar for third reading and final passage.
Representative English. Said with great style. Members, you have heard the motion. Seeing no amendments, the motion before us is the passage of the report of the Committee of the Whole. Mr. Shebel, please open the machine and members proceed to vote. Kelty Story Sukla. Please close the machine. With 41 aye, 18 no, and 6 excused, the report of the Committee of the Whole is adopted. Announcements and introductions. Representative Soper.
Thank you, Madam Speaker. Members, I have a very important introduction to make. We are joined on the House floor by Miss Teen Mesa County for 2025, Venice Mitchell. She is a 7th generation Colorado native where she proudly calls Mesa County home. Miss Mitchell is a sophomore at Caprock Academy where she excels as a National Honor Society student and is actively involved in her school community as the host of 747 News Show. Ms. Mitchell is a varsity volleyball player and also gives back as a coach for 3rd and 4th grade volleyball students in the City of Grand Junction's Recreational League. She's been a mentor for many different young athletes. Ms. Mitchell is also an avid downhill skier and embraces the outdoor spirit of Colorado that we love so much. Her love for skiing reflects her adventurous nature and determination. In June 2025, Venice Mitchell will compete for the title of Miss Colorado's Teen in the Miss America Opportunity, a program that empowers young women to use their voices to create meaningful change. As part of her community service initiative, Superpower Thinking, Ms. Mitchell advocates for more options and choices in education for students with learning differences or difficulties, such as dyslexia and ADHD in K-12 schools and higher ed. She continues to make an impact as a student leader, mentor, and advocate. And we just want to welcome her today to the House floor.
Representative Soper.
And thank you, Madam Speaker. And Ms. Mitchell's mother also happens to be an elected official. Commissioner Bobby Daniels is Commissioner of Mesa County.
Thank you. Representative Wilford.
Thank you, Madam Speaker. I did sign up today. Members, House, State, Civic, Military, and Veterans Affairs Committee will not be meeting.
Representative Ricks.
Hi, members. Business Affairs and Labor is not meeting today either.
Representative Valdez.
Energy and Environment. We are meeting today at 1:30 in room 107. It will be a light day. We will hear 1177 for action only and 1268. 1:30, we're going to be downstairs, 107.
Representative Lukens.
Thank you, Madam Speaker. The House Education Committee will be meeting at 1:30. We are meeting in the Old State Library today, and we are hearing 3 bills, House Bill 1293, Senate Bill 87, and House Bill 1178.
Thank you. Representative Lindstedt.
Thank you, Madam Speaker. The House Finance Committee will be meeting today on adjournment to hear House Bill 1080, 1289, 1194, and 1096.
Representative Johnson.
Thank you, Madam Speaker. Everybody, it's an exciting day. Logan County cattlewomen have decided to feed us steak along with beverages and all the fixings today at 6 p.m. at the First Baptist Church of Denver. I encourage you to come. It's an event you do not want to miss.
Yum. Representative Hamrick.
Thank you, Madam Speaker. I'd like to welcome the Volunteers of America here today. We had their president and board members here earlier. And just to remind you of what the Volunteers of America do, they work with the Southwest Safe House, Meals on Wheels, Community Meals Program, Healthy Aging, Handy Person Program, Theodora Family, Hotel, Veteran Services, and so much more. So they're around in the building. If you see them, just say hi. And I would also like to get a red picture later today.
Representative Luck. And Representative Martinez and Morrow and AML Winter and Representative Armagost.
Thank you, Madam Speaker. We're just coming down here as the Pueblo contingent +1 that we've adopted in. Unfortunately, a couple of nights ago, 3 of our police officers...
Excuse me, Rep. Luck. Members, your attention, please.
Thank you, Madam Speaker. Unfortunately, in Pueblo, a couple of nights ago, 3 of our police officers were shot and are now in the hospital, and so we just wanted to request a moment of silence in their honor and request prayers for their quick healing. Thank you, members.
Thank you, representatives. Our hearts go out to those injured and their families. Madam Majority Leader.
Thank you, Madam Speaker. I move to lay over the balance of the calendar to Friday, March 21st, 2025.
Seeing no objection, the balance of the calendar will be laid over until tomorrow. Madam Majority Leader.
Madam Speaker, I move the House stand in recess until later today.
The House will stand in recess until later today.